Okay. I'm glad you Dr. Milton. Let's see, Ms. Bridgewater, good afternoon. What's the
Good afternoon.
afternoon?
Our reset date is going to be November the 15th.
Okay, thank you. And let's see. Who do we have at the South Annex?
Position 14, Padilla Darby.
And if we're all
Judge.
okay, good afternoon, Ms. Lewis. People are still coming in.
Your Honor, I will be Michael Jordan today, as you can see.
I will change it, Ms. Holly.
Oh, that's okay. I just want, as long as he knows. I just thought, look, it's Halloween, trick or treat. So, hey.
All right. Good afternoon, Ms. Padilla Darby. I'm Judge Eric Mora. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Ms. Padilla Darby, you've been charged in case 22 CR 00745 through E with simple battery family violence. It's my understanding from Mr. Howard that this is Ms. Padilla Darby's first arrest. Okay, and who is presenting for the state?
This is my case, Your Honor. Good afternoon.
Good afternoon, Ms. Duncan. You can proceed.
This incident occurred on October 29, 2022 at 600 Greens Ferry Avenue Southwest. Officers were dispatched to the location for a dispute call. When they approached apartment 710, they heard yelling and began knocking on the door to that unit and announcing their presence to the people inside. Once the door was open, officers witnessed the defendant in this case striking the victim, who is her husband, Mr. Cedtron Lynn, that's Sedtron, last name Lynn. Apparently there was some dispute after the defendant had consumed large amounts of alcohol, about accusations of infidelity, and that's when the attack started. The victim in this case did attempt to defend himself against the attack from the defendant in this case. However, officers were able to eyewitness the hitting going on when the door was open. The state wants to make the court aware that obviously the officer was an eyewitness to this incident. There was alcohol involved, and it seems to be that a child was also present during the stepdaughter was present during the altercation as well. The state has some concern here about the risk of reoffense, but we are aware of this defendant's limited criminal history. We do have some concerns because they are married. In addition to that, given that we do have concerns about the cycles of violence and possible intimidation of this witness, our office was not able to make contact with the victim in this case, and out of abundance of caution, the state is going to be requesting a $2,500 surety. No further contact with the victim. Third-party child contact, stay away from that incident location. 1 day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state.
Thank you. Good afternoon, Ms. Kim. Is this your case? You're on mute.
Yes, Your Honor, this is my case. I would like to recommend for a signature on bond. This is her first ever arrest. She is 28 years old, Your Honor, and we are not opposing to stay away nor no further contact because actually they have been separated for the last 2 months. So they don't live together at this point, and they don't have any child together either. The daughter is her daughter from another person. So he does not have to have any child custody issues or child visitation issues with the daughter right now. She has a job. She actually started her job 2 weeks ago. So she wants to keep her job since she's going to be soon to be a single mom, and she's the only one who supports that 8-year-old daughter. So it's very important for her to have that job, and she's been working there for only 2 weeks and now she's here, so she's very afraid that she's gonna lose her job. She graduated from high school, and we would like to request that she gets signature on bond through pretrial today. Thank you.
Does she need to go back to that address to retrieve any belongings?
No, she has to go back to 3849 Root Green Point. That's her place. So
Okay, so she doesn't have anything at the 600 Greens.
nothing.
All right, it's going to be a $2,000 signature bond through pretrial, 1-day anger awareness, stay away from the incident location, no further contact with Mr. Lynn, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Padilla Darby.
Thank you.
Next, we have position 17, Sensley.
Hello.
Good afternoon, Ms. Inslee. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. You have been charged in case 22 CR 007451E with simple battery family violence. Is there a history, Mr. Howard?
Third arrest, 2016 simple assault, dismissed, and a 2015 driving without a valid license.
Okay. Good afternoon, Ms. Tortorella.
Good afternoon, Your Honor. Just to advise the court, there's a cross defendant in this case, Mario White, and I'm not sure if Your Honor wants to hear both at the same time.
Just go ahead with Sensley at the present time. And we'll see. I would imagine that Mr. White is probably in courtroom too, and we'll get to him as when we get to him. I'll remember the facts, Ms. Tortorella.
Okay, Your Honor. Yes, Your Honor. So for this case, we're recommending the state's recommending a $3,500 surety bond. The conditions is for the defendant to stay away from the incident location at 207 Harwell Place. That's HAR as in Robert, WELL Place Northwest in Atlanta. No contact with the cross defendant, Mario White. 1-day anger management, no drugs or alcohol, no weapons, and no violations of Georgia law. Your Honor, this incident occurred on October 30th, 2022, yesterday at the incident location 207 Harwell Place. This defendant does pose a significant threat and danger to the person of Mario White. The officer Jay Brown of the Atlanta Police Department, he was dispatched to the incident location in reference to a fight call. While on his way, the officer was actually flagged down by the defendant, Zeria Sensley, at the Valero gas station off of Donald Lee Hollowell Parkway. The defendant advised her mother had called police because she was involved in a dispute with her live-in boyfriend, Mario White, while the defendant was on the phone with her mother. Defendant said at some point during the dispute, Mr. White put his finger on her face and punched her in the face multiple times. And then defendant was arrested. The officer could not figure out the primary aggressor in this incident. And all these events that occurred in Fulton County, Georgia. As far as intimidation of the victim witness here, Your Honor, it's foreseeable due to the facts of this case. Also, Your Honor, this happened yesterday, so there needs to be a sufficient cooling off period. This defendant has 3 cycles, Your Honor, and she had a prior violent offense of simple assault here in this jurisdiction with a different male victim. She received a $1,500 signature bond through pretrial. It was dismissed because the victim did not appear at the call to calendar. And this is according to the no pros order 16 MAGC-06254 is the case number. And nothing further from the state.
Good afternoon, Ms. McLeod. Is this your case?
It is, Your Honor. Good afternoon. My client is 24 years old. She has no convictions on her record. She is gainfully employed, Your Honor, as a manager at a financial institution. She is the mother of a 9-year-old daughter, and she takes care of that 9-year-old daughter. She tells me that this was an unfortunate incident that happened between herself and Mr. White, whom she has known since the 5th grade. They have known each other. She tells me that she would prefer for them to have no further violent contact, Your Honor, because she's known him pretty much more than half of her lifetime. And she regrets the incident that happened, but she says she was not the primary aggressor and it just got a little out of hand. She's not afraid of him. They actually do live together, Your Honor. And her daughter also lives there. And she said she was on the phone with her mom, and her mom was the one who called the police. Neither herself nor Mr. White called the police. Based on the fact that my client has no criminal record, she's gainfully employed, she is a mother of a 9-year-old child, I would ask the court to give her a signature bond so that she can get out of jail. I think there is no history there, Your Honor. The one cycle that she had some time ago, over 7 years ago, and she was quite young, that was dismissed. And the other was a traffic-related violation. Thank you, Your Honor.
Okay, is this Mr. White in courtroom 2?
Hi, good afternoon, Judge. No, this is, you need Mr. White.
If he's available, I can go ahead and, since it's a cross defendant, I can go ahead and do these both at the same time if you all would like.
Okay.
Thank you. Good afternoon. Mr. White, I'm Judge Eric Morrow. You've been charged in case 22 CR 007460E with simple battery family violence. Also, is there a history in this case, Mr. Howard? Mr. Howard?
Yeah. 3rd arrest. Last arrest was 2016 for obstruction. And a 2013 affray that was dismissed.
And Your Honor, just to fill you in on the facts involving Mr. White, he states that after they had the verbal altercation, he was trying to leave the incident location, and that's when he was punched on the back of the head by the defendant, and then she pulled on his hair, on his hair. So Your Honor, that is his statements to the police, and again, the officer could not figure out who the primary aggressor was. If Your Honor does grant them a signature bond, the state does request no contact at this time. Mr. White was found in possession of 2 firearms, Your Honor. And given the circumstances of this matter, I think it's for the safety of both parties here that they have no contact at this time.
Legal possession, obviously.
Obviously, Your Honor, he wasn't arrested for the firearms.
And he didn't attempt to use them either.
Ms. Kim?
Yes, Your Honor, Mr. White does not oppose to the no further contact nor the stay away because they do not live together. They will not be living together anymore because Mr. White was actually leaving the place and she was he packed up everything and there's nothing for him to go back and retrieve at all at this point. So we do not oppose, stay away from that incident location, nor a no further contact at this point. Mr. White would like to, I think he is qualified for signature on bond because all those things are kind of remote and he does not have other violence history. He is 25 years old and he has been here in Georgia for all his life. He does not have any children and he's not married. He has his family members here in Georgia. He works 2 jobs. One, he got a new job at Emory Hospital about 2 weeks ago. And he's also working as a cook for about 3 months. And he completed up to 9th grade. Because of his learning disability, it is very important for him to keep his job because it's kind of hard to find the job and keep the job. So we would like to recommend him for a signature on bond so he can return and be productive worker. Thank you.
All right, for Ms. Sensley, it's going to be a $2,000 signature bond through pretrial, one-day anger awareness class, no further contact with Mario White, and no drugs, alcohol, or weapons while out on bond. For Mr. White, it's going to be a $2,000 signature bond through pretrial per the judge, one-day anger awareness, a stay away from the Harwell Place address, and no further contact with Ms. Sensley, no drugs, alcohol, weapons while out on bond.
Thank
Okay.
you.
All right, good luck to both of you all.
Our last one will be position 18, Tanner.
Good afternoon, Ms. Tanner. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. You have been charged in case 22 CR 007457Y with battery against a female who is pregnant. Is there a history, Mr. Howard?
No.
Ms. Tortorella?
Yes, Your Honor. Give me one moment. The state's recommending for this matter a $5,000 surety bond. The conditions is to stay away from the incident location, which is 373 Moreland Avenue Northeast, apartment 204 in Atlanta. No contact with the victim. Her name is Kayla Watkins. The first name is KHAYLA, Watkins, traditional spelling. One-day anger management, no drugs or alcohol, no weapons, and no new violations of Georgia law. Your Honor, this incident occurred on July 15th, 2022 at the incident location in Moreland Avenue. The defendant does pose a significant threat and danger to the person of Kayla Watkins. Your Honor, on July 16th, 2022, which was a day after the incident occurred, Officer N. Evans of the Atlanta Police Department was dispatched to the incident location in reference to a dispute. Victim Kayla Watkins advised the officer that the day prior, defendant Ania Tanner, which was the victim's ex-boyfriend, came to the incident location and knocked on her door. Ms. Watkins opened her door and the defendant pushed his way inside and began a dispute. Ms. Watkins said the defendant then choked her, leaving a visible mark on her neck. The physical altercation led to the bathroom, where the defendant closed the door and again placed his hands around Ms. Watkins' neck. Ms. Watkins said she used her free hand to bang on the walls to alert her neighbor to come to her aid. Ms. Watkins said her neighbor from apartment 201 came to the incident location and separated the defendant from her until the suspect left. Ms. Watkins is pregnant and she advised the defendant of this a month after they broke up. The defendant was eventually arrested and these events occurred in Fulton County, Georgia. Your Honor, the victim has filed her own warrant against the defendant, and this was filed on July 19, 2022. They have a hearing date of December 5th, 2022. Your Honor, we're also looking into this matter to transfer to the Superior Court as for the charges of aggravated assault, strangulation, and false imprisonment. To add, Your Honor, it's foreseeable that this defendant will intimidate the victim in this matter. The fact that the victim has personally filed a warrant against the defendant is very telling, Your Honor. It's also foreseeable due to the facts of this case. The fact she attempted to get the defendant to leave the location multiple times, and the defendant refused and continued to attack her during the incident. After the incident, Your Honor, it's important to note the defendant returned 2 more times, knocking on the victim's door. APD case number 221-970051. The defendant came a 3rd time after this incident where he pulled the fire alarm and fled the scene. The fire department had to come, and this is Atlanta Fire Department case number 2204-30 531. We're understanding that this defendant has no criminal history. However, Your Honor, these are very serious actions that occurred against a person, Miss Watkins. And for that reason, Your Honor, we're asking for that $5,000 surety bond for the defendant to again stay away from the incident location, no contact with the victim, and all the other conditions already stated before this court. Nothing further.
Okay, Ms. Kim?
Yes, Your Honor. Ms. Tanner is 23 years old, Your Honor, and we have no objection to stay away or no further contact. They have not had any contact ever since then. She has a different address. They don't live together. They actually never lived together. They don't have any children together. So there's no reason that they have to get together at all. Miss Tanner is actually self-employed, and he washes cars to make a living, and he wants to become a businessman to build up the wealth. And she graduated from high school. And we would like to request for a signature on bond because just because someone filed a warrant application, that does not mean that that actually happened. There was no witnesses. There was no camera. Nothing was recorded. It's just purely what she said. We would like to request for a signature on bond. Thank you.
And Your Honor, just to correct the record, the victim did provide the officer with photos of her injury the next day and photos of the apartment, that it was in a disarray. Also, it's important to note there had to be a neighbor to come in and separate the parties to get the defendant off of the victim. Nothing further.
All right, it's going to be a $5,000 signature bond through pretrial, 1-day anger awareness, stay away from the Moreland Avenue apartment 207 address, no further contact with Ms. Watkins, and no drugs, alcohol, or weapons while out on bond.
Thank you.
Good luck to you.
Your Honor, did you say, I'm sorry, 1-day anger management or?
Yes.
Okay, thank you.
Yeah. Okay, are we done at the South Annex?
Yes, Your Honor. Thank you so much.
You're welcome. Have a good afternoon. Be safe.
Thank you.
Judge Morrow.
Yes.
Good afternoon. I do apologize for interrupting. I had placed a few announcements in the chat regarding breakouts for position 7 and also for position 12 with an interpreter to complete the interview for today.
Do we have a courtroom today that Ms. Gann can speak with her client in a breakout or not?
Yes, we would just have to, I just have to wait till Officer Norris comes back in, and then he can take the Spanish interpreter case to the courtroom.
All right, so just let me, whenever you all get that arranged, just let me know, okay?
Okay, not a problem.
Thank you. Who do we have?
This is gonna be position 12. No, I'm sorry, position 3, Mr. Cooley.
Good afternoon, Mr. Cooley. I'm Judge Eric Morrow. This is a state court expedited accusation calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You have been charged in case 22 CR 007450E with Superior Court contempt and failure to maintain lane or improper lane change. Is there a history, Mr. Howard?
It's 4th arrest. Last was 2021 kidnapping battery DV out of Cobb County. That appears to be open. Also open case in Fulton, ag assault, kidnapping, battery DV, simple battery DV. That's it.
Afternoon. How are you?
Good, Your Honor. How are you?
Well, thank you.
Thank you. All right, Your Honor, this incident occurred on October 20th. An officer conducted a traffic stop at Lee Street and Oglethorpe Avenue Southwest for improper lane change. Upon contact with the driver, who was the defendant, the defendant provided his driver's license. The officer asked him if there were any firearms in the car, which he stated he had a handgun sitting between his seat. He gave the he gave consent to recover the handgun from the vehicle. After running the defendant's name, the officer discovered that the defendant had been arrested for the ag assault, kidnapping, and battery in Cobb, to which the defendant told the officer that he was out on bond for those charges. The officer then contacted Cobb County Sheriff's Office, who advised that as a part of the defendant's bond conditions, he was to have no weapons, including firearms. And the officer then contacted the district attorney's office, who said that he needed to be arrested for violating his bond conditions. Your Honor, and I don't know if all of this was said. There's the 8/20/21 ag assault, which is our open case, which he's already out on a $5,000 good bond. There's the 9/20/21 kidnapping, battery, family violence, simple battery, family violence, which he's out on a $5,500 good bond. And there's the kidnapping, battery, family violence, and false imprisonment from Cobb, which is also open. They couldn't give me the bond amount. And so that is open as well. So he's got all of these charges, Your Honor, and he obviously has violated bond. For that reason, the state would ask that he have a $5,000 surety bond, and no alcohol, drugs, or weapons while out on bond. Nothing further.
So, are there two charges, Ms. Bacchus?
Yes, Your Honor. So the contempt of superior court. So that would be $4,500. I'm sorry for not breaking it down. $4,500 for the contempt of superior court and $500 for the failure to maintain lane.
Okay, thank you.
Yes.
Ms. Gant?
Thank you, Your Honor. Mr. Ladarius Cooley is 24 years old. He has been in the Atlanta, Georgia area his entire life. He is the proud father of 3 children, ages 6, 2, and 1. He graduated high school and currently is employed as a drummer in a local church part-time. He also states that he works part-time as a barber, and he has been doing this since 2018. Your Honor, Mr. Cooley strongly denies the allegations. Firstly, he denies being Mirandized. He states that the police approached him in a very aggressive manner and searched his car prior to informing or asking any questions. Furthermore, he states that he was in the far right lane as opposed to the lane where he could not complete a turn. So he disputes that. Furthermore, Your Honor, he is here today with the contempt of a superior court charge. And we believe, Your Honor, that this is not the appropriate forum. Due process requires that he be given proper notice of his charge. And we do not believe that a first appearance is the appropriate forum for a contempt hearing. And as I understand it, the punishment for contempt of court order is imprisonment, which we certainly don't want, or a fine, not a first appearance bond. So therefore, in this matter, Your Honor, I am requesting a signature bond on Mr. Cooley's behalf. Thank you.
Your Honor, and the state would strongly oppose that, signature bond. He's got, like I said, all of those open cases. He's already out on bond. He clearly does not respond to legal instruction or legal process. And I did speak with the district attorney in Cobb. Will also be they will be speaking with pretrial to do a bond revocation. But as it pertains to him violating the bond in our county, we would ask for that surety bond.
And again, Your Honor, I do apologize for interrupting. He certainly is presumed innocent in any open cases. And what we have here is a traffic offense, Your Honor. And we heard a lot about his open cases for violence, but this is a traffic matter. And again, due process requires proper notice, and not just, having this heard in first appearance, Your Honor.
And let me just a quick question, Ms. Bacchus. The aggravated assault, the 2021, he is a condition of, and that's in Fulton County, and a condition of that Fulton County bond was also no weapons. Is that right?
Let me look that up. I can tell you for sure that the latest one, which is the one that's in Cobb, that one had a no weapons, but let me check into to see really quick.
I can't imagine that they're going to let him out on bond for kidnapping and not have that as a stipulation.
I would agree, Your Honor.
Alleged kidnapping.
Sorry, Your Honor, I'm trying to find this. I don't know if I'm not seeing the bond order because it's in the DA system and not ours. Hold on.
Okay, you're fine. I'm going to let the Superior Court in both those Superior Court cases deal with whether or not he's in violation of any bonds that he has for them. And as Ms. Gant said, given that the underlying issue in this is a traffic violation, it's going to be $1,000 signature bond through the jail for the contempt charge and a $500 signature bond through the jail for the failure to maintain lane. And if he has violated that bond, I'm sure Ms. Bacchus, you'll be getting in touch with someone from Superior Court, the DA, to let them know that he was arrested on this matter.
I will. Thank you,
Okay.
Your Honor.
All right, Mr. Cooley. No drugs, alcohol, or weapons while out on bond in this matter also.
Thank you, Your Honor.
All right. Good luck to you, Mr. Cooley.
All right, thank you.
Position 6, Mr. Isamani. You gotta sit right here. And then put your mask up for me too.
Thank you.
Good afternoon, Mr. Isamani. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 22 CR 007452J with battery family violence. I've been told by pretrial that this is Mr. Isamani's first arrest. Ms. Bacchus.
Yes, Your Honor. Officers on October 29th, officers responded to the incident location, which is an extended stay at 1050 Hammond Drive. Upon arrival, the officer spoke with both the defendant and the victim, Ms. Selena Williams, who said that they have been married for 15 years and they have been residing at that extended stay together. And according to her, the defendant had been drinking and an argument started. She tried to leave and the defendant forcefully stopped her by grabbing her arm, causing an abrasion to her shoulder. Our office did have the opportunity to speak with Ms. Williams. She said that they're married, they live together, they don't have any children, that they were staying at that extended stay and that they had had a verbal altercation on the 28th where the police were called by a neighbor. And then they had the physical altercation on that next day where a neighbor called the police as well. And as a result of that, they've been kicked out of it, out of the extended stay. And she said that she had to be out by today. She said that she's not in fear, but she doesn't want to deal with this and she does not want contact with the victim. She may be on, Your Honor, if Your Honor would like to sound for her. The state is recommending a $2,000 surety bond, no further violent contact, 1-day anger awareness, and no alcohol, drugs, or weapons.
No further violent contact?
Oh, I'm sorry, no further contact, Your Honor, based on what the victim said. My apologies.
Oh, no, you're fine. I just wanted to make sure that
Thank you.
She's right. Ms. McLeod?
Yes, Your Honor. My client is 54 years old and has been, as it has been stated, this is his first arrest. My client, he is quite well educated, he tells me, but at the moment, Your Honor, he suffers some blindness, so he can't see, can't drive. So that has limited his movement and what he's able to do in terms of work and so on. I would ask the court to give him a signature bond so he can get out of jail. I did speak with the wife and she indicates that she is not fearful of him, but she says she believes the relationship is essentially over for them. She's no longer interested in maintaining this marriage. So she would prefer no further contact, even though she's not afraid of him. She did indicate that she has some of his belongings, Your Honor. I would be happy to give those back to him, including his cell phone.
Okay. I see a Selena on the line. If that is Ms. Williams, if you would like to address the court, now is your opportunity. You do not have to address the court, but if you would like to address the court, I'll need for you to activate your camera and I'll need to swear you in if you would like to say something.
Yes, I'm
Yes.
here.
All right. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. What would you like to tell the court?
Well, it's so unfortunate that it happened the way it did. I do know that and understand that he's over the 15 years, he's never been physically violent towards me. Of course, we have verbal altercations a lot, but this time it was just unfortunate that it happened the way it did. Like I told the counselor earlier, I will see that he gets the proper area that he needs to go, wherever he needs to go. But as for me, I don't want any dealings with him again.
Okay. And you do have some belongings that you'd like to get back to him?
I have all his things.
Okay. And is there someone that can get him his belongings other than you?
I can have someone to I can arrange some things.
Okay, so if I'm gonna have him not to have any further contact with you. So he'll have to get his belongings through a third party, okay?
Okay.
All right, so it's gonna be a $3,000 signature bond through the jail. He didn't have any reason to go back to that extended stay, does he, Ms. McLeod?
No, Your Honor, they can't go back there. And she has indicated, Ms.
Okay.
Williams, that she's taken out all their stuff from there and that they can't go back there.
So he's to stay away from that extended stay. He's to have further contact with Ms. Williams and no drugs, alcohol, or weapons while out on bond. And Ms. Williams is to make arrangements to get him his belongings through a third party. Well, he can get his third party from Ms. Williams through a third party. All right. Anything further?
Yes. Can I say something to him?
I've already given you a signature bond, sir. So I would have, I'm sure that Ms. McLeod would advise you that you have a right to remain silent and that anything you say can be used against you. So you still have these charges pending and you're going to have to come back at a later date to answer for them. So it's probably best that you don't say anything right now, okay?
That is correct. And you have my telephone number. If you do not, you can ask the officer at the jail for it and give me a call.
Okay.
All right. Well, good luck to you, sir. And you also, Ms. Williams.
Thank you.
Position 11, Kennedy.
Good afternoon, Mr. Kennedy. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video? Is that a yes?
Yes.
Okay, thank you. Mr. Kennedy, you've been charged in case 22 CR 0074618 with driving under the influence of alcohol per se, improper passing of a stationary towing utility maintenance or recovery vehicle, possession of open alcohol container, and driving under the influence of alcohol less safe. Is there a history, Mr. Howard?
What the rest? 2017 probation for no license. 2009 distribution of drugs out of New Jersey. That was a felony conviction. CS3. Hold on. And the 08 theft of property conviction out of Texas. That's it.
Okay. Ms. Duncan.
Yes, Your Honor, this incident did occur on yesterday in the area of Merlock Bridge Road. Officer Bacon was conducting a traffic stop in that area when a black Toyota Camry driven by the defendant passed his vehicle while his blue lights and sirens were directly engaged in the emergency lane. And the officer notated that the far left lane was available for the defendant to merge over into. However, the defendant remained in the lane closest to his vehicle and passed directly next to him and did not slow down at any point in time. After that, the officer initiated a traffic stop on that defendant, and immediately upon stopping the vehicle and approaching it, noticed an odor of alcoholic beverage coming from inside the vehicle. The officer indicated that the driver of the vehicle, which is the defendant's speech, was thick and slurred. His eyes were bloodshot. The defendant at the time admitted to drinking alcohol and agreed to do standardized field sobriety testing. The officers indicated that during that field sobriety testing, the defendant showed many clues of impairment. He was arrested and read the implied consent for the proper age group. And he consented to the state breath test. And at that time, the state breath test showed a concentration of 0.153. When officers searched that vehicle, they found a red plastic cup on the cup holder that contained an orange liquid that had an odor of alcoholic beverage. The warrant does indicate that the officer did some sort of passive testing on the liquid, and it was positive for alcoholic beverage at that time, while in the defendant's driver history does indicate a citation in 2016 for driving without a valid license. And then there's another license denial suspension from 2015 as well. We do have concern that this defendant may be a danger to other drivers on the road, as with any person who drives while intoxicated is very dangerous to that person and others on the road. It could have caused serious injury, as this officer was attempting to make a lawful stop on another person, and this driver endangered all parties involved by not moving over or slowing down to facilitate that stop and keep the safe distance that's required by law. We do have some concern that this defendant has a likelihood not to respond positively to the legal process. There is a probation violation in this defendant's record. For these reasons, Your Honor, given that the state is going to be requesting a $5,000 split bond, that's $2,000 surety for the DUI per se, 500 signature to pretrial services for the improper passing, 500 signature to pretrial services for the open alcohol container, and 2,000 surety for the DUI less safe. We're also going to ask for no driving unless approved with a limited permit through DDS, and no further violations of Georgia law. Nothing further from the state.
Ms. Camp.
Thank you, Your Honor. Mr. Deshaun Kennedy is 43 years old. He has been in the Atlanta, Georgia area for 10 years. He has 2 children, ages 20 and a minor child who is 8 years old. He completed high school and is currently employed at a Mexican restaurant in Duluth. He has been in that position for about 2 months. Therefore, he is on probation, has some concerns about losing his job. Your Honor, Mr. Kennedy is presumed innocent and he strongly denies the allegations. I am requesting a signature bond on Mr. Kennedy's behalf. And if Your Honor determines that he's ineligible, then I would ask for a split bond. That would be $2,000 for the DUI per se. We are unopposed to the signature bonds for the improper lane change and the possession of an alcohol container. We would ask for a signature bond for the DUI less safe. And further, Your Honor, regarding I neglected to mention this earlier. However, we would ask that Your Honor not consider any blood alcohol testing results, as the state has not laid the proper foundation to submit that evidence. Further, the driving offenses, Your Honor, are remote, 2016, 2015. We heard about a probation violation. That was in 2017. We did not hear about any FTAs. So therefore, we do not believe that Mr. Kennedy is a flight risk and that he will not respond to legal process. Further, we are opposed to any driving restrictions that are not in place. We would ask that he be allowed to drive in accordance with his DDS privileges. Thank you, Your Honor.
All right, for the DUI DUI per se, it's going to be a $750 good bond. For the improper passing, a $250 good bond. For the possession of open container, a $250 good bond. And for the less safe DUI, a $750 good bond. It makes it a total of a $2,000 good bond. No drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
Thank you, Your Honor.
Good luck to you, Mr. Kennedy.
Position 9, Johnson.
Good afternoon, Mr. Johnson. I am Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, yes.
Thank you. Mr. Johnson, you've been charged in case 22 CR 007462A with battery, family violence, cruelty to children in the 3rd degree, and willful obstruction of a law enforcement officer. Is there a history, Mr. Howard?
This is 10th adult arrest. He got history out of the state of Washington. Last arrest was August of this year for assault, obstruction. Charges are pending. 2014 harassing communication, assault, firearm possession, unlawful possession of a firearm, basically. Those were convictions. 2013 failure to comply. 2012 firearm, unlawful firearm possession, that was another conviction. 2011 theft conviction. Another 2011 firearm conviction. 2011 theft conviction. His first 4 cycles were juvie arrests. So that's all. This is first Georgia arrest.
Okay, Ms. Duncan.
Yes, Your Honor, this incident took place at 3100 West Forest Side Court on October 30th, 2022. In this instance, Officer Rhea responded to that location in reference to a dispute. They met with the victim in this case, Ms. Anicia Sanchez, ANIESSA Sanchez, common spelling. She was inside of a vehicle and she advised officers that her child's father, who she properly identified, had been abusing her for a couple of days. She stated to officers that her cell phone was inside the location and that she just wanted it to go back, to get it back, because she stated to officers that there was an altercation because she stated to the defendant that she was going to book her a flight to go back home to Washington State, and the defendant became upset. Officers observed the physical presence of the victim as having 2 black eyes, scratches on her cheeks, bruise marks on her breast, and bruises on her back. Officers did indicate that she seemed to them visibly shaken and distraught. She indicated to officers that the defendant had been being aggressive for a while, and that earlier that day he had pinned her up against the bedroom wall and grabbed her by her neck. Officers did notate visible marks on her neck at that time. She stated that there was a juvenile, ZV, who was in the home at the time of the act of battery family violence. And officers notated that when they went to the incident location address to knock on the door to speak to the defendant, and they identified the fact that they were outside and that the place was surrounded, the defendant at first would not open the door. And once the door was opened, the defendant continued to indicate that they needed a warrant to come inside the home. However, they indicated that they were not intending to come inside of the home and that they were just investigating the domestic violence case, and that they wanted him to come outside. At some point, the defendant began reaching inside of his clothing. At that point, officers did warn him to put his hands up, and they did pull their issued weapons at that time. However, they were able to take the defendant into custody, and upon taking him into custody, he refused their commands in terms of walking to the vehicle. He did not want to put his feet inside the vehicle, and once inside the vehicle, he continued to kick the patrol vehicle's rear passenger side windows. And before getting in the vehicle, he continued to pull away. In this case, the state has a concern about the risk of reoffense, given that this defendant does have several domestic violence incidences in his record. And we have a concern about the intimidation of this particular witness, as it's indicated that they have a child together. So we have some concern there. Plus, given the victim's statements at the time, we do have some concern that the ties to the community are insufficient. This defendant does have a recent incident out of the state of Washington as early as August of 2022 that is still pending. We have some concern about the flight risk as well, given that those instances are still pending and the defendant is now in the state of Georgia. Given those facts and circumstances, Your Honor, given the injuries alleged by the victim and the the injuries observed by the officers. We have a particular concern for the health and safety of this particular victim. So we're going to be asking for a $7,500 total surety, and that's broken down as 4,000 surety for the battery family violence, a 2,500 surety for the cruelty to children in the third, and a $1,000 surety for the willful obstruction of law enforcement officers. We'd ask for no further contact with the victim in this case, third-party child contact if Your Honor deems appropriate, a one-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state.
Ms. Gant?
Thank you, Your Honor. Mr. Gerald Johnson is 29 years old. He informs me that he actually, the residents of this particular location, Your Honor, he states that neither he nor his sister lives there. He states that that is actually, I'm sorry, neither he nor the complaining witness lives there. He states that this is his sister's residence, and Nakisha Duncan, Your Honor. Mr. Johnson has family here, including a 10-year-old daughter, and he tells me that he does not share that child with the complaining witness. He denied having any children with her, unless I'm mistaken. My client will, I guess, confirm that with him. He completed high school. He has an associate's degree in business. He is currently employed at Boeing and has been so for the past 2 years. He strongly denies the allegations and he is presumed innocent, Your Honor. He states that he does not want any contact with Ms. Sanchez. Therefore, we do not believe that there's any risk whatsoever of intimidating this witness, even though he is presumed innocent, although he is presumed innocent. We are requesting a one-time law enforcement so that he may return to that residence to confirm that Ms. Sanchez isn't there, so that he may continue being there with his sister. We are requesting a signature bond, Your Honor, and if Your Honor determines that he is ineligible, then I would ask for a bond of no more than $2,000, and that would be $500 for the cruelty to children, $1,000 for battery family violence, and $500 for the obstruction of law enforcement officers. Thank you, Your Honor.
Your Honor, as it's indicated by the warrant that they share a child together, if that's an issue that the defendant has, I believe that can be resolved through contact based on a legitimation procedure at that time. But as the warrant states, and given that we weren't able to make further contact with the victim, we request that the court grant our recommendation as stated on the record, nothing further.
Well, if he says that the child's not his and they're not asking for third-party contact, then there doesn't appear to be a child that he wants to have contact with. So that being said, for the battery, it's going to be a $3,000 good bond. The cruelty, $1,000 good bond. The obstruction, $1,000 good bond, making it a total of a $5,000 good bond. No further contact with Ms. Sanchez. Stay away from Ms. Sanchez's address. As far as the 3100 West Forsyth Court address, he can go back there on one occasion with law enforcement to make sure that Ms. Sanchez is not residing there. And if she doesn't, then he obviously can go back there. No drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
Good luck to you, Mr. Johnson.
Yeah.
Position 1, Brasher.
Good afternoon, Mr. Bradshaw. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Mr. Bradshaw, you've been charged in case 22 CR 00744D with driving under the influence of alcohol less safe and failure to keep in the proper lane, an HOV violation. Is there a history, Mr. Howard?
Yeah, 13 total. He got DUI convictions from 2016, 2 from 2017, 1 from 2018. And he had a 2016 DUI that was reduced to reckless conduct conviction. Last arrest was 2018 for a suspended license. That's pretty much it. But he was not recommended due to the history.
Ms. Ms. Bacchus?
Yes, Your Honor. This incident occurred yesterday. An officer was patrolling I-75 North near Moores Mill Road when he observed a vehicle cross the double solid lines exiting the HOV lane. The officer caught up to the vehicle and conducted a traffic stop. Upon approaching the driver's side, or the driver, the officer advised the driver that crossing the double lines was a violation. During that time, the officer, I don't have the full report yet, Your Honor. It appears that the officer did ascertain from the stop that the defendant was under the influence of some kind of substance and was less safe to drive, and placed him under arrest for that as well. Based on the history, Your Honor, there was actually 2 reckless drivings, one from 2015 and one from 2016, that were reduced to reckless driving from a DUI, in addition to the 4 others. And now we have another one here. For that reason, Your Honor, and he also has an extensive driving history. For that reason, Your Honor, the state is asking for a $10,000 surety bond, no driving, and no alcohol, drugs, or weapons while out on bond. And actually, Your Honor, this will be during discovery week, we will be transferring this up as a for it being the 5th DUI within 10 years.
What's the breakdown, Ms. Bacchus?
9, 5, and 5, 9,500 and 500.
Okay, so he has on the sheet, does he have 3 charges? So the failure to keep in the proper lane and the HOV lane violation, those are 2 separate charges?
Right, so 9,000 and then 500 times 2.
Okay. Ms. Gant?
Thank you, Your Honor. Mr. Marcus Brashear is 33 years old. He has been in the Atlanta, Georgia area for 3 years. He has a mother here, Your Honor, but he states that he is estranged from his mother and that she is not a resource. He obtained and also completed a trade in carpentry. He is currently employed with a trucking logistical company. He has been in that position for about 4 months. Your Honor, he strongly denies the allegations. And while I do acknowledge my client's history, I would bring to the court's attention that the defense has not received a police report, and the warrant is basically a bald accusation. It doesn't indicate any reason whatsoever why Mr. Brashear was thought to be under the DUI, I guess, in line for a DUI less safe charge. Therefore, I am requesting a signature bond on Mr. Brashear's behalf. And if Your Honor determines that he is ineligible, then I would ask for a more reasonable bond of no more than $2,000. And that would be $1,000 for the DUI less safe and $500 for the remaining charges. And we are certainly opposed to any driving restrictions. We want him to be able to drive in accordance with his DDS privileges. Thank you, Your Honor.
PD Gant, did you say that he has a commercial driving position?
I did not. I stated that he works for a trucking company. He is not a driver for that company.
Okay.
All right. For the DUI less safe, it's going to be a $3,000 good bond. Failure to keep proper lane, a $500 good bond. HOV lane violation, a $500 good bond. Makes it a total of a $4,000 good bond. I'm going to have him report to DUI court within 2 days of his release. And he's not to drive except for getting back and forth to work. No drugs, alcohol, or weapons while out on bond.
And Your Honor, may you add to legal counsel and to doctor's appointments, Ms. Driver?
Of course, Ms. Gant, that's fine.
And Your Honor, my apologies. Go ahead, Ms. Bacchus. I'm sorry.
Oh, I was actually wondering, I didn't know if he was eligible for DUI court, but also I needed the 4,000. So it's $4,000 good, 3,500 times 2. And what are the other conditions, Your Honor?
Except for work purposes, legal purposes, and what was the third one, Ms. Gant? That was
Maybe.
medical
Medical
purposes.
medical appointments.
Okay.
Drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
And my apologies for interrupting. If we could for a second go back to position 11 for the DUIs on that case, did Your Honor impose any driving restrictions?
Be happy to go back to you, okay? Anything further on Mr. Bashir?
Nothing
Nothing
from the
further
defense,
than
Your Honor.
Okay, good luck to you, Mr. Bashir. Now, Ms. Duncan, I don't believe I imposed any driving restrictions on anyone else today.
Okay, I just want to be clear for the record that there were no other restrictions.
Okay.
There were not any.
Thank you.
Who do we have next?
Position 5, Haynes. And then after that, Judge, we do have Officer Norris in the courtroom 1 and courtroom 3, and is ready for the Spanish interpreter.
Is he already on?
He's coming in now, Judge. And Judge, also, I just want to let you know that your volume or your audio keeps like blinking in and out. I don't think anybody has said anything to notice it, but I've been noticing that you say something and then it goes out, then it comes back in.
That's correct.
Okay, well, you all have to let me know, because I don't see any problem on my end, and the volume is as far as I have it up. I'm not sure if I may be too far away from the computer. Is that any better?
That's better. I hear you now.
Okay, well, you should have told me 20
I
minutes
did.
ago.
You were talking, but I couldn't get interrupted at the time.
Yeah,
Sorry.
you just let me sit here and look crazy. Okay, thank you.
No.
All right, Mr. Haynes, good afternoon. And let's go ahead and, is this your case, Mr. Haynes, Ms. Gant?
Yes, it is. If we can do that after, do the breakout after Haynes' case.
Okay, all right, very good. I'm happy to do that. Mr. Haynes, good afternoon. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video. Do you agree to have the case heard by video?
Yes, it's fine.
Thank you. Mr. Haynes, you've been charged in case 22 CR 007454G with criminal trespass and theft by taking. Is there a history, Mr. Howard?
This is fourth arrest. Last was 2021, fleeing an officer. Before that was another 2021, fleeing, sale of marijuana, driving without valid license. Another count of selling, sale of marijuana, suspended registration, 2020 suspended license. He went to felony earlier. He got split bonds. I think part of it was like 9,000, another part of them with no bonds, and he got 4 holds.
What were the charges?
I don't know. I just got the information from my coworker. I have to look it up. I'm sure the state knows. He got a probation hold out of Jonesboro Road, FTA warrant out of Sandy Springs, FTA out of Fayetteville, and a fraud warrant out of Marietta.
Sparkus?
Yes, Your Honor. So the charges for felony earlier was felony theft by receiving. I did read that report. I believe he was caught with this property from this theft in a vehicle, a stolen vehicle. And so that was that. Then he's got possession of crime tools, fleeing and eluding, reckless driving, speeding, driving while suspended, giving false name, and failure to maintain lane. That case number is 22 CP 213573. This incident occurred, believe on August 31st. Miss Mariko Perkins called the police to 626 DeKalb Avenue. That's the West Inman Lofts. She told officers she had packages delivered to the mailroom, with one package being a work issued laptop that was valued at $1,230, and the other package was a wig she had ordered at $200. The officer was able to obtain video footage from which he observed a black male search around the room, and then he left with 3 packages. 2 of the packages, as I said, that were stolen belonged to Miss Perkins. And then I'm sorry, let me check this date to make sure. And then it looks like at a later time, the officer was contacted by an officer out of DeKalb who advised that the male had sold the laptop to Ideal Pawn located at 3593 North Crest Road. And when the pawn shop, I guess, provided a photo, it was the same male from the mailroom. I believe there's a $2,000 surety in place, and that is $1,000 on each, the criminal trespass and the theft by taking. Your Honor, based on the recent charges, I have 2, 3, 4, 5, 6, 7. I have 7 cycles, even though pretrial said 4. Based on and the 4 holds for FTAs, probation violations, fraud, and the thefts in the history, Your Honor, the state is asking for a $5,000 surety bond, a stay away from that incident location, which again is the West Inman Lofts at 626 DeKalb Avenue Southeast. No further contact with Miss Mariko Perkins, and a theft class. Nothing further.
Ms. Gant.
Thank you, Your Honor. Mr. Dominique Haynes is 30 years old. He has been in the Atlanta, Georgia area since 2003. He does have family here, including his mother. He completed high school and he is currently employed for an entertainment management company. He has been with that particular company since 2015. He strongly denies the allegations. He certainly was unaware of the warrant. I do acknowledge my client's history. However, he is presumed innocent in any open cases as well as with this case. I am requesting a signature bond on Mr. Haynes' behalf in light of the multi-$1,000 bond that he received in felony today. He has no means of paying that. And as I heard from pretrial, he did not receive a bond for some of his offenses, and he has several holds. And we do believe that a signature bond will facilitate his release when he gets bond to deal with those holds from the other counties. We are opposed to the theft class, as he will likely not be able to afford that, nor even complete it within the time that the court requires. Therefore, again, we're requesting a signature bond. We are unopposed to the stay away and the no contact orders. And if Your Honor determines that he is ineligible for a signature bond, then we'd ask for a bond of no more than $1,000, and that would be $500 for each count. Thank you.
I'm going to leave the bond where it is, $1,000 on each count, making for a $2,000 good bond. No further contact with the alleged victim. Stay away from the DeKalb Avenue address, and no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Haynes.
Thank you. Position 15, Palmer.
Good afternoon, Mr. Palmer. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Palmer, you've been charged in case 22 CR 007446C with theft by shoplifting. Is there a history, Mr. Howard?
This 9th arrest. We got history out of Georgia and California. Let's see. Last arrest in Georgia was 2013 for disorderly conduct. He had a battery conviction from 2011 out of Clayton County. Last arrest in California was 2005. Possession of a controlled substance conviction. Yeah, that's pretty much it.
Tortorella? Thank you, Mr. Howard.
Yes, Your Honor. This incident occurred on September 25th, 2022 at the Family Dollar, 5403 Old National Highway in South Fulton. Corporal D. Mitchell of the South Fulton Police Department responded to the incident location in reference to a shoplifting. Upon arrival, the officer met with employee Christina Balu, who said a bald black male, later identified as defendant James Palmer, walked to the food section of the store, walked out with several TV dinners and candy located inside the defendant's shirt and pants. The items stolen were a total of $30. The incident was caught on the store surveillance camera. The defendant was arrested, and all these events occurred in Fulton County, Georgia. Your Honor, the state's recommending a $2,000 signature bond through pretrial. Stay away from the incident location is one of the conditions, is the family dollar. An anti-theft class, no drugs or alcohol, no weapons, and no new violations of Georgia law. Nothing further.
All right, it's going to be a $2,000 signature bond through the jail. Stay away from that family dollar, and no drugs, alcohol, or weapons while out on bond. Does that suit you, Ms. Kim?
Yes, Your Honor. Thank you.
All right, good luck to you, Mr. Palmer.
Position 16, Robertson.
Good afternoon, Mr. Robertson. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're doing by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. You've been charged in case 22 CR 0074447C with theft by shoplifting. Is there a history, Mr. Howard?
No.
Ms. Tortorella?
Sorry, I was
Okay.
muted, Your Honor. This incident occurred on October 18th, 2022 at the Target 375 18th Street in Atlanta. Officer M. Bratton of the Atlanta Police Department responded to the incident location in reference to shoplifting. The officer met with the loss prevention officer, Watts, who said the suspect, later identified as defendant Akil Robertson, entered the store and stole a JanSport book bag and 40 Dove deodorants. The defendant passed all points of sale without paying for the items worth $320.30. The defendant was eventually arrested, and these events occurred in Fulton County, Georgia. Your Honor, the state's recommending a $2,000 signature bond through pretrial to stay away from the incident location at Target, an anti-theft class, no drugs or alcohol, no weapons, and no new violations of Georgia law. Nothing further.
All right, it's going to be a $2,000 signature bond through the jail. Stay away from that Target on 18th Street, and no drugs, alcohol, or weapons while out on bond. Does that suit you, Ms. Kim?
Yes, Your Honor.
All right, good luck to you, Mr. Robertson.
Thank you.
Position 8, James.
Good afternoon, Mr. James. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you have your case heard by video?
Yes, sir.
Thank you. Mr. James, you've been charged in case 22 CR 0074448J with simple battery, family violence, and theft by taking. Is there a history, Mr. Howard?
6 total. He don't have any violence or any theft. Last arrest was 2020, suspended license, no low. He got a dismissed obstruction from 2019. Disorderly conduct conviction 2018. Yeah, that's it.
Ms. Duncan?
Yes, Your Honor, this incident occurred on August 27, 2022 at 1690 Browning Street. In this instance, officers responded to that location, and they met with the victim in this case. Her name is Denaiah Brown. That's DANAIHA Brown, common spelling. She stated to officers at that time that her and the defendant have a child together. And what had occurred was that she was speaking to her friend in Creole, and the defendant got upset because he believed that she was making fun of him. She stated that the defendant started going through her purse and saw that she had a couple of dollars in cash in there, and that he said it was his. And when she went to grab the money from him, because she said that it was not his, and that he could not take it, he hit her 3 times. She stated to officers that she ran to the laundry room to try to block out the hitting, but was unable to, and the defendant in the case pushed her around that laundry room. And she stated that after that, it was time for him to go to work, so he took her iPhone and left that location. The defendant was identified by the victim positively from his driver's license photograph, Your Honor. We did get a chance to speak to the victim. She stated that they're no longer in a relationship and they no longer live together, but they do share a child. She stated that the incident location was the defendant's mother's home and that she does not live there. She has not seen the defendant since the incident. And given that, Your Honor, we're going to be requesting a make sure my math is right. Yes, and surety in the amount of 2,500 for the simple battery family violence, and a surety in the amount of 1,500 for the theft by taking. No further contact with the victim, third-party child contact. We're not going to ask for a stay away as she is not located at that address anymore. We're going to ask for 1-day anger awareness, no alcohol, drugs, and weapons, and a theft class. Nothing further from the state.
Ms. McLeod?
Yes, Your Honor, my client is 23 years old. He is a native of Atlanta. He denies that he was the aggressor in this incident that the prosecutor described, Your Honor. He said he was surprised, and so was the alleged complaining witness, when she heard that there was a warrant out for him, because that was not her intention at the time. She says she was just angry with him, Your Honor. My understanding is that she is currently out of the state of Georgia and will be out of the state of Georgia for a while, visiting with relatives in another state. As the prosecutor stated, they do not live together and they really have not had any significant interaction. They're no longer in a relationship other than talking about the shared child that they have. He has no violent history, Your Honor, and we don't foresee that they're going to live together or be in a relationship going forward. And based on what she communicated to the prosecutor, she doesn't seem to be in any fear of him, Your Honor. So I would ask the court to consider giving him a signature bond, as he does not have any violence in his past. He is gainfully employed. He shares a child with her, and he's only 23 years old. Thank you, Your Honor.
And just for the record, Your Honor, the victim did not clarify whether or not she feared the defendant, and she also did not indicate whether or not she wanted contact. So I do not feel it's safe and in the best interest of this victim to assume those things. And given the facts and circumstances and out of abundance of caution, we think our recommendation is reasonable. Nothing further from the state.
For the simple battery, it's a $3,000 signature bond through pretrial. For the theft, it's a $1,000 signature bond through pretrial, which makes it a total of a $4,000 signature bond through pretrial. 1-day anger awareness, no further contact with Ms. Brown, third-party transfer for visitation with the child, and no drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
Thank you, Your Honor.
Good luck, Mr. James.
Position 4, Ellison.
Good afternoon, Mr. Ellison. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Good morning, Board. Yes, sir.
Okay, thank you, Mr. Ellison. You've been charged in case 22 CR 007449Y with battery. Is there a history, Mr. Howard?
10 total. Last arrest was 2020 ag assault battery DV that appears to be open out of the cab. 2019 ag assault DWAP. 2012 you had an ag assault DV. They now processed that, but he was convicted for battery DV. 07 failed to appear for simple battery. Came off an 06 arrest. That's all.
Marcus?
Yes, Your Honor. This incident occurred back in December of 2021. Officers were dispatched several times to the area of Wimbledon Road and Piedmont Road before being contacted by the victim. And the address that the victim gave was 594 Wimbledon Road. The victim, who's Mr. Michael Walker, advised that he came home to his apartment. He was intoxicated at the time. He said he walked into the apartment where it was dark and he was attacked by his boyfriend, who's the defendant, where he was repeatedly hit with a closed fist and open hand, and he was hit with the bathroom scale. The victim had several abrasions and bruises to his face, neck, mouth, and the back of his head. And when the officers got there, the defendant was no longer on scene, hence why this is a warrant case. Mr. Walker stated that he had given the defendant a key to his apartment to allow him to get things from there. And I believe the officer was able to obtain video footage from the neighbor's Ring camera, and that caught some of the incident on film, as well as the officer was able to look in the system and locate this other incident between this same victim and defendant, where I believe the victim was stabbed by the defendant in that case. They were both charged with ag assault in that case. That 2020 ag assault battery family violence that's open out of DeKalb, that is the same victim, and he is already out on bond. For that reason, Your Honor, the state is asking for a $5,000 surety bond. No further contact with Michael Walker. Stay away from the incident location at 594 Wimbledon Road. I believe that's unit 5203. And no alcohol, drugs, or weapons. If there are any other belongings, they're a third-party transfer. Nothing further.
Have you spoken with Mr. Walker or anyone from your office, Ms. Pappas?
No, Your Honor, I don't believe so. My recommendation is based off the fact of the open cases and the previous incidents.
Okay, Ms. McLeod?
My client is 38 years old, Your Honor. He is gainfully employed as an event planner, he tells me. He and the alleged victim had been in a relationship for some time, Your Honor, and as the prosecution indicated, there was at least one episode where they were both were arrested and charged. They are no longer in a relationship, Your Honor. They have not been in a relationship for more than a year now. In fact, the alleged victim no longer lives in the state of Georgia, and they have no contact, Your Honor. Based on that, Your Honor, I would ask the court to consider giving my client, I do acknowledge that he has some history, but give him a reasonable bond because he's not in a position to pay a $5,000 good bond at this time. And given the fact that this incident happened some time ago, well over a year ago, and that the alleged victim no longer lives in the state of Georgia, my client could not possibly be a threat to him going forward, Your Honor. Thank you.
All right, it's going to be a $2,000 good bond, no further contact with Michael Walker. I don't know if it's necessary or not, but stay away from the 594 Wimbledon Road address. No drugs, alcohol, or weapons while out on bond. Good luck to you.
Thank you.
Position 20, Williams.
Good afternoon, Mr. Williams. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Good afternoon, and yes, I do.
Yes, thank you, Mr. Williams. You've been charged in case 22 CR 0047459D with driving under the influence of alcohol, less safe, illegal stop, stand, or parking where prohibited, and willful obstruction of a law enforcement officer. Is there a history, Mr. Howard?
Fourth arrest. Last arrest was in August. Felonious assault, resisting arrest out of Ohio. It appears he may have an open DUI out of Cobb County. Hold on. Got a 2019 battery. It says stricken off with lead to reinstate. That's out of Illinois. And he got a couple of holds. He was arrested 2021. Yeah, okay, that's the DUI out of Cobb. He got a hold in Cleveland for assault. Hold out of Marietta, failure to appear. That's all.
Who's representing Mr. Williams?
I do, Your
Okay,
Honor.
I just wanted to make sure you were with us, Ms. Kim. Ms. Tortorella?
Yes, Your Honor. The state's asking for the $10,000 surety bond to remain as set, the $10,000 total. The DUI is a $7,500 surety. The illegal stop is a $1,500 surety, and the obstruction is a $1,000 surety. The conditions is no driving, no drugs or alcohol, no weapons, and no new violations of Georgia law. Your Honor, this defendant does pose a flight risk and a risk of reoffending. He currently has a hold, a fugitive from justice hold out of Cuyahoga County. the sheriff's office there in Ohio for that felony assault case. It's an open case. He also has a hold out of Cobb County, 21 SCB 03899 for an FDA on his DUI drugs case. He got 2 counts of DUI drugs and the other charge is failure to maintain lane. It's an open case. Your Honor, the state has already reviewed his case for DUI court. This is actually his second and 5. He's not eligible at this time due to the fact that he has an open felony assault case out of Ohio. Your Honor, this incident occurred on October 29th, 2022 at Metropolitan Parkway in Atlanta. This defendant does pose a significant threat and danger to the people of Fulton County. Officer M. Brown and Officer Martinez of the Atlanta Police Department were en route responding to a 911 call at 3:50 a.m. when they observed a red Ford Focus with a Wisconsin registration plate parked perpendicular to the right lane of southbound traffic, and it was near the intersection of Metropolitan Parkway Southwest and I-85, the exit ramp. The vehicle appeared to be in an abandoned condition. There was nobody inside. Due to the safety hazard the vehicle created to other motorists, Officer Martinez abandoned the 911 response and called a tow truck. An inventory search was conducted, and officer observed a large empty bottle of wine inside the vehicle. I'm sorry, Your Honor. I'm sorry. Hold on a second. I apologize, Your Honor. That was my son. I apologize.
Fine, Ms. Citarella. Go ahead.
So he was basically, where was I? So he was waiting for the tow truck, and as he was waiting for the tow truck, there was an inventory search done where he found an empty bottle of wine inside the vehicle. As a defendant, as he was waiting for the tow truck, the defendant then came to the scene, Julian Williams. And he spoke to the officer, and as he was speaking to the officer, Your Honor, he detected an odor of alcohol emitting from his person. The defendant agreed to perform a field sobriety testing and found clues in the horizontal gaze nystagmus, the walk and turn, and the one leg stand, which gave the officer a probable cause for DUI less safe. Officer observed during testing that the defendant was also unsteady on his feet, and during arrest, the defendant could not remember why he was being arrested, though the officer repeated the reason several times to the defendant. Implied consent was read for suspects ages 21 and over. The officer took the defendant's response as a refusal due to the defendant yelling and threatening officers. While in jail, the defendant physically resisted and pulled away from the officers, causing them to fall to the ground. The defendant was then sent to Grady Marcus Trauma due to his out of control behavior and had to be strapped to a bed. And these events did occur in Fulton County, Georgia. And for that reason, Your Honor, he has, again, those 2 holds. This is his second and 5, Your Honor. We are asking for a $10,000 surety bond. Absolutely no driving. This defendant should not be driving. He refused implied consent. A 1205 form should have been sent already to DDS to suspend his license. Nothing further.
Ms. Kim?
Yes, Your Honor. Mr. Williams is 23 years old, Your Honor, and he actually resides in Chicago, Illinois. He's been here for his movie projects for about a year. He stays at his uncle's place, who is a U.S. Colonel, and he is residing here in Georgia. So he does have a local address where he stays, and he still has he's an actor, and he still has movies that he has to film. So he's going to be here for a while, even longer. And he's been an actor ever since 2013, and he has some college education. He studied communication and physical therapy, and right now we would like to request for as low as possible. He only has one person who can help him out, in terms of getting the bonds, and I have not been able to contact him. And so we would like to make sure that he is able to get out of the jail. So if Your Honor is not inclined to give him a signature on bond because of the open charges, we would like to request for maximum $1,000 good bond for DUI, and of course, illegal stop. It's a traffic, so it can be a signature on bond, jail, and also, Your Honor, those two charges are open. However, he's presumed to be innocent, and he is actually working on it. He claims that he's innocent, and that's it, Your Honor.
For the DUI, a $3,500 good bond. For the illegal stop, a $500 good bond. For the obstruction, a $1,000 good bond. It makes it a total of a $5,000 good bond. No driving while out on bond. No drugs, alcohol, or weapons while out on bond. Good
Your
luck.
Honor, can he drive for limited purpose only?
Your Honor, again, a DDS 1205 has been filled out. It was a refusal, so his license has been suspended.
He's the only one who can get his car back from the toll place.
As long as there's to be no driving, as long as he has a suspended license. So if he gets his license back, then
okay,
he can drive. But as long as his license is suspended, obviously he won't be able to drive. So he'll have to get someone to help him with retrieving the vehicle.
Okay.
All right. Good luck to you, Mr. Williams.
Thank you.
Position 10, Jones.
Judge, they're back from the breakout room, just letting you know.
Okay, thank you. Good afternoon, Mr. Jones. I'm doing fine. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Mr. Jones, you've been charged in case 22 CR 007455Y with criminal trespass. Is there a history, Mr. Howard?
Fifth arrest. Last arrest was last month for obstruction. On probation for battery DV as of August. Also on probation for obstruction as of September 29th. August 2021, that was a battery DV. August 12th, 2022, failure to appear. And September 7th, 2 counts of simple assault, 1 count trespass. So I guess they sent all that to SAP and he got the probations for those. That's it.
Okay.
Yes, Your Honor. That offense from September 29, 2022 was a guilty plea for criminal trespass and willful obstruction of a law enforcement officer. The state would like to know for the court that the incident location was the same location that is in question today before the court. This offense did occur on October 29th, just a month after pleading guilty to criminal trespass at that location, 5 Lamar Avenue. The defendant returned to that location and was encountered by Officer Khatib and Officer Harleman in reference to a trespass call. When the officers arrived on scene, they noticed the defendant standing in the front yard while in a verbal dispute with Mr. Christopher Favors regarding an ongoing dispute with the defendant's ex-girlfriend, Ms. Talia Hightower. At that point, Officer Harleman detained the defendant. And when Officer Khatib saw who the defendant was, he stated to him, because he was the one who issued the initial criminal trespass and arrest, didn't I just arrest you for criminal trespass? And at that time, the defendant stated that yes, but I'm trying to fix issues with Ms. Hightower. There was a case number from September 6, 2022, APD 222491558I, where he was arrested for criminal trespass from that location. Ms. Hightower indicated to officers that she never welcomed the defendant to that location or on that property and did not want him on that property. He was arrested and taken into custody at that time. As Your Honor is well aware, given the facts of this case, we have some concern about the risk of reoffense, as this defendant was told to stay away from this location, not only in a bond order given by Judge Law on September 8th, but in addition to plea conditions taken on September 29th, 2022. We have some concern about flight risk, given that this defendant has a recent FTA from August of 2022, and we do have some concern about this defendant's likelihood to positively respond to legal process, given that this defendant was warned, arrested, and pled guilty and was made aware to stay away from that location and decided to go back, regardless of what the court had mandated in this case. And as far as his well-being and the safety of others, I would like to note for the court initially, in that September 6th incident, Mr. Favors was a part of that incident as well. Apparently, there are several individuals that live in this location, and every time the defendant comes to this location, he kind of gets into it with Mr. Favors. Given the facts and circumstances surrounding this case, Your Honor, the state is going to be requesting that a bond in the amount of $1,500 surety for the criminal trespass. And it's criminal trespass. So $1,500 for the criminal trespass. No further contact with Christopher Favors. Again, to stay away from that 5 Lamar Avenue address. No one-day anger awareness. No alcohol, drugs, and weapons, and no further violations of Georgia law. The basis for that anger awareness would be that when he arrived at that location, according to the warrants, Your Honor, he was acting loudly and trying to fight Mr. Favors at that time. So we're going to request for that anger awareness. And given their previous history, we think it's more than reasonable under these circumstances. Nothing further from the state.
Let's see. Mr. Jones, we see you there with your hand up. So we will acknowledge you, okay? So just give us a second, all right? You do have a right to remain silent. Anything you say can be used against you. If you need to talk to Miss McLeod, I will give you that opportunity to do so, but let her speak on your behalf, okay? Okay. Ms. McLeod, it seems like he was indicating that he wants you to call him.
I'd be happy to do that, Judge.
Okay, so why don't we, courtroom 2, if we can go ahead and let Ms. McLeod speak to her client, and maybe I can go to courtroom 3 and do the interpreter case. Does that work for you all?
Yes, that's fine, Judge.
That works for me, Judge.
Okay, thank you. All right, so who do we have in courtroom 3?
Position number 12, Judge.
Okay. Good afternoon, Madam Interpreter. If you'll raise your right hand for me.
Yes, Your Honor.
Do you swear or affirm that you will translate from Spanish to English and English to Spanish to the best of your ability?
I do, Your Honor.
Okay, thank you. And how do you pronounce his last name?
His last name is Malvais Boizo.
Malvais Boizo.
Pedro Malvais Boizo.
Okay, Malvais. Good afternoon, Mr. Malvais. I'm Judge Eric Mora. We're conducting this hearing by video. Do you agree to have your case heard by video?
Buenas tardes, señor Malvais. Estamos conduciendo esta teleaudiencia para evitar el contagio. ¿Está de acuerdo con que tratemos su caso de esta manera? Yes.
You have been charged with driving without a valid license and driving under the influence of alcohol less safe.
Señor, usted está acusado de manejar sin licencia y el segundo cargo es por conducir incapacitado por los efectos del alcohol.
Pre-trial that this is Mr. Malvais's first arrest.
Para los servicios previos al juicio, este es el primer arresto del señor Malvais.
Ms. Duncan.
Yes, sir. This incident did occur yesterday in the area of Georgia 140.
Esto ocurrió ayer en el área de Georgia 140, la autopista.
The defendant in this case was found in actual physical control of a moving vehicle in that area when officers noticed that he failed to respond to a green light.
Este acusado estaba físicamente conduciendo un vehículo en esta área cuando los oficiales notaron que él no prestó atención a una luz verde.
Officers also indicated that he remained stopped at said green light for an extended period of time, weaved within a single lane, and operated the vehicle at a slow rate of speed.
También los oficiales observaron que él permaneció detenido en esa luz por un mayor tiempo que el necesario y después empezó a serpentear en un solo carril y avanzó muy despacio.
Officers indicated that the defendant was in the leftmost lane in relation to traffic, and at times when they approached the defendant, his speech was slurred and slowed.
También los oficiales indicaron que él manejaba en el carril izquierdo de esta área descrita. Cuando ellos se acercaron, notaron que él balbuceaba y hablaba despacio.
Officers indicated that the defendant's eyes were red and watery and that they detected an odor of alcoholic beverage on or about the defendant's breath.
Los oficiales también dijeron que este acusado tenía los ojos rojos y vidriosos y también sintieron un olor a alcohol que venía de su aliento o del área del interior.
Officers indicated in the warrant that this defendant admitted to consuming alcoholic beverages prior to driving.
También los oficiales dijeron, de acuerdo a esta orden de arresto, que este acusado admitió haber bebido alcohol antes de haber sido detenido.
And the defendant was driving a Mazda with a Georgia specified tag. After the GCIC and NCIC officers indicated that the driver appears to be unlicensed.
También el acusado conducía un vehículo Mazda registrado en el estado de Georgia y los policías también indicaron que este conductor no tenía licencia válida.
And based on the officer's training and experience at that time, they believe they had enough evidence to place a defendant under arrest for DUI less safe and expired or no license.
Entonces, por esta manera, por esta evidencia presente, los oficiales tuvieron que iniciar el arresto considerando lo observado como suficiente prueba por manejar sin licencia y conducir incapacitado por los efectos del alcohol.
Here, the state has concern for the danger to the specific defendant, given that he's likely driving while intoxicated and the other motorists on the road.
La fiscalía le preocupa que este acusado sea un peligro debido a que manejó intoxicado, poniendo en peligro a sí mismo como conductor y a otros conductores alrededor de él.
Even though the defendant has very limited criminal history, the state has the concern as stated previously. So we think that a $2,500 split bond is more than reasonable in this case.
Debido a que, a pesar de que este es el primer arresto, nos causa mucha preocupación en la fiscalía, por eso pedimos una multa de $2,500 porque la consideramos razonable por los dos cargos.
The state is requesting a $2,000 surety for the DUI less safe and a $500 signature bond through pretrial services for the expired or no license charge, in addition to no alcohol, drugs, and weapons, no further violations of Georgia law, and no driving unless the defendant obtains proper license, insurance, registration, and is permitted by DDS.
One moment, please. Debido a esto, se detalla de la siguiente manera: $2,000 de multa bajo garantía por el cargo de manejar incapacitado por los efectos del alcohol, $500 de fianza bajo firma a través de los servicios previos al juicio por manejar con una licencia no válida o sin licencia. Queda prohibido el uso de drogas, alcohol y armas, que no incumpla ninguna ley del estado de Georgia, y que si lo hace es bajo la tenencia de una licencia de conducir con seguro y registrada a través del servicio de transporte.
Nothing further from the state.
Nada más de parte de la Fiscalía.
Yeah.
Thank you, Your Honor. Mr. Pedro Malve is 52 years old.
Señor, su señoría, el señor Pedro Malváez tiene 52 años.
He has been in the Atlanta, Georgia area for 9 months and married for 35 years.
Él ha vivido en la área de Atlanta por 9 meses y ha estado casado por 35 años.
He is proud father of 4 children, ages 29, 27, 25, and a 10-year-old who is handicapped.
Él es el padre orgulloso de hijos de 29, 27, 25 años y de una menor de 10 años que es discapacitada.
He's very concerned about being released so that he can tend to her.
Le preocupa mucho el quedar libre para poder atender al menor, la menor.
He completed 6th grade in Mexico, and he is currently employed at a local tree cutting company for 8 months.
Él terminó su 6º grado en México y ha estado trabajando por 8 meses en una compañía cortadora de árboles.
He strongly denies the allegations and clearly has a language barrier and denies making any statements to police.
Él niega todos los alegatos debido a que su barrera de lenguaje, él niega haber hecho ninguna declaración a los policías.
This is his first arrest and he's presumed innocent. Therefore, we are requesting a signature bond.
Este es su primer arresto, por lo tanto pedimos una fianza bajo firma.
And if your honor determines that he's ineligible, then I would ask for a bond of no more than $1,000.
Y si su señoría determina que el acusado no cumple los requisitos, pido que le establezca una fianza no mayor de $1,000.
My apologies, a split bond, Your Honor, 500 signature for the expired license and no more than 1,000 for the DUI less safe.
Perdón, $500 por la licencia vencida y $500 por manejar incapacitado por los efectos del alcohol.
Thank you, Your Honor.
Gracias, su señoría.
All right, it's going to be a $500 good bond for the driving without a valid license and a $1,000 good bond for the DUI less safe, making it a total of a $1,500 good bond.
Thank you.
Va a ser por el primer cargo de manejar sin licencia $500 y por manejar incapacitado por los efectos del alcohol son $1,000, un total de $1,500 de fianza.
No drugs, alcohol, or weapons while out on bond, and obviously no driving without a valid license.
Queda prohibido el uso de drogas, alcohol y armas mientras él esté libre bajo fianza y por supuesto no manejar sin una licencia válida.
Good luck to you, sir.
Buena suerte, señor.
Thank you, Your Honor.
All right. Thank you, Madam Attorney. We appreciate your help this afternoon as always.
You're very welcome. My pleasure, Your Honor. Have a good evening.
Okay, you have a good day.
Excuse
also.
me, I'm sorry.
Yes, okay.
What was the bond amount again, please, Judge?
It's a total of a $1,500 good bond.
Okay, thank you, sir. Appreciate it.
You're welcome. Okay, and let's see, can we go back to courtroom 2?
Yes, going back to position 10, Jones.
Okay, and I think that you're up, Ms. McLeod. We're ready, Ms.
Yes,
McLeod.
Your Honor.
Okay.
Yes. My client is 19 years old. He denies the allegations made by the prosecution. In fact, he tells me, Your Honor, that he was not at the location at all. He said he was close by. There's a church nearby, and he was actually at the church. He was walking to the church when the complaining witness, who is the father of his girlfriend, called him over to speak with him. He denies that he tried to fight him or anything like that. He says that is not true at all. He says that he has not been back to that location at all. He was just in the church. So he was surprised that the police officers arrested him because he was absolutely not at the house, and he said he did not try to fight anyone. What he tells me, Your Honor, is that the young lady, Miss Hightower, had contacted him and his grandmother because she wanted to speak with them. And that is the reason why he was nearby, but he did not go there because she had agreed to come to see him because she wanted to talk to him. So, Your Honor, I would ask the court to consider giving my client a signature bond so he can get out of jail because he absolutely denies these allegations, Your Honor. And had he tried to fight, as the prosecution was saying, he would have been arrested for something else. As it was, he was charged with criminal trespass, and he denies that he was actually at this location. He says he never went there at all. He was just nearby. He is presumed innocent, Your Honor, and I think based on what he tells me, that there is a possibility he will be found innocent if and when this matter goes to trial. He's not in a position to post a good bond. Thank you, Your Honor.
As defense knows, charges are up to prosecutorial discretion. In this instance, we decided against the additional fight charges because it indicated that there was some type of argument. However, I do want to make it clear for the record that officers encountered this defendant on that property as indicated by the officer who had previously arrested him and another officer who was unfamiliar with the defendant on the scene. Nothing further from the state.
It's going to be $1,000 good bond. Stay away from the Lamar Avenue address. No further contact with Mr. Favors or Ms. Hightower, and no drugs, alcohol, or weapons while out on bond.
Your Honor, there was never any stay away or no further contact with Ms. Hightower in any of the previous orders, Your Honor. It was just said that he should not go back to the location and he should have no contact with the gentleman.
However, Ms. Hightower did indicate to the officers that she did not welcome the defendant onto that property and she did not want him onto that property. And she lived there, so we judge.
Well, at this point in time, until everything is worked out, there's to be no further contact with Ms. Hightower either.
Thank
All
you.
right. Good luck to you, Mr. Jones.
Thank you.
Position 13, Melovich.
Good afternoon, Mr. Malvich. I'm Judge Earl Moore. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
I consent.
Thank you. You have been charged in case 22 CR 007463G with, excuse me, attempting to misrepresent tag, driving while license was suspended or revoked, no insurance, theft by receiving stolen property, and expired tag or unregistered vehicle. Is there a history, Mr. Howard?
It is 11 total. Last arrest was 2018. Probation violation. Underlying charge is cruelty of an elderly person. He was convicted of that in 2016. 2014 ag assault. He was found not guilty on that. And the charge for inflicting pain on an elderly person. 2013 misdemeanor theft by taking. Got a 2013 probation for burglary, 2009 probation violation, and a 05 probation violation. That was a conviction. And a theft by receiving. That was from the 90s though. I don't see anything driving.
All right, thank you, Mr. Howard. Ms. Duncan?
Yes, as pretrial stated, Your Honor, this defendant does have several convictions, including 2 for theft by shoplifting, 1 from not theft by shoplifting, my apologies, 1 for theft by receiving stolen property and 1 for theft by taking. In this incident, Your Honor, there was a flock alert sent to officers in the area, and Officer Davidson responded to that alert in regards to a stolen license plate in the area of Hembry Road and Maxwell Road in the westbound area. There was another officer, Sergeant Desiree Sher, patrolling that area in search of that stolen license plate. They found that stolen license plate attached to a vehicle, a black Audi that the defendant was driving. Officers initiated a traffic stop in that area. When they spoke to the driver of the vehicle, who was identified as the defendant, he stated to officers that he had found the license plate on the side of the road about a month ago and affixed it to his vehicle. He stated that he bought the vehicle in Michigan at an auction. Officers asked the defendant why he didn't have a registered license plate for the vehicle, and he told officers at that time he had a suspended license and multiple issues that had prevented him from getting the proper license plate. The Audi did come back as a car purchased out of Michigan, but officers indicated that the defendant was driving and it was not registered, but the vehicle itself returned to State Farm Mutual, but there was no valid insurance provided for that vehicle. Officers also indicated at the time, based on a criminal history search, that apparently this defendant's license has been suspended since 2008. We do have some concern about the risk of reoffense in this case. This defendant does have multiple theft convictions. If it weren't for their remote nature, they would have been accepted as a felony transfer. However, we're here today. We have some concern about the likelihood to respond positively to the legal process. The defendant does have probation violations as well as several other probation violation convictions in the defendant's history. Given that, there is a preset bond in this case of $4,200 total. We're going to request that remain as set, and the breakdown is as follows: $1,000 surety for attempting to misrepresent tag, $1,000 surety for driving while license suspended, $600 surety for no insurance, $1,000 for theft by receiving stolen property, and then $600 surety for expired tag or no registration. Officers indicated also that that tag did not have the requisite sticker in the corner of that tag that he claims he found on the side of the road. This defendant has had a previous arrest for a similar offense in the past. Given that, we think our recommendation is more than reasonable. And in addition, we're going to ask for no driving unless this defendant has a valid license, insurance, and registration, along with no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state.
So the theft by receiving is for the tag?
Yes.
All right, so these are all gonna be SOBs through the jail. For the attempting to misrepresent, a $250 SOB through the jail. For the suspended license, a $500 SOB through the jail. For the no insurance, a $500 SOB through the jail. For the theft, a $1,000 SOB through the jail. And for the expired tag, a $250 SOB through the jail. So that's $2,500 SOB through the jail. No drugs, alcohol, weapons while out on bond, and obviously no driving without a valid driver's license. Is that fine with you, Ms. Gant?
Yes, Your Honor, thank you.
All right, good luck to you, Mr. Mount.
Thank you.
So $2,500 SOB through the jail, Your Honor?
Yes, that's correct.
All right. Next, we have position number 2, Mr. Brown Clark.
Good afternoon, Mr. Brown Clark. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 22 CR 007445H with battery family violence. Is there a history? Mr. Howard?
I got a first arrest.
Okay, yeah, I see that here. I'm sorry. Ms. Bacchus?
Yes, Your Honor. This incident occurred yesterday. Officers responded to 295 Windsor Way in regards to a dispute call. Upon arrival, an officer approached the front door and could immediately hear a male and a female inside the residence screaming at each other. After numerous attempts of knocking and trying to announce, he ended up entering through an open garage door and announced himself. He made contact with the defendant. Then the defendant went to go get himself decent. He started talking to the victim, who is Miss Brittany Locken, who said that the defendant started getting ready for his shower. She took his cell phone, started going through his phone, saw messages from other women, became upset. So when he came and asked her what was wrong, she said she didn't want to leave, and that, or she said that she didn't want to talk to him and that he needed to leave. Based on the fact that she had gone through the phone and saw what she saw. She said he began yelling at her, that she told him to leave again. She attempted to shut the bedroom door, but he began to push the door from the opposite side. And while they were both pushing, I guess his hand slipped off the door and hit her in the forehead. And so the officer did observe a bloody mark on her forehead, and he could also see marks on her arm. When the officer spoke with the defendant, his account was similar, except that he said that during that altercation, there was more back and forth, and that the victim slapped him as well. They both advised the officer that they live at the incident location together. Our office was able to speak with Miss Locken. She said that they're in a relationship, they live together, they had a child that passed away. She said she was not the one who called the police, and that she does not fear the defendant, wants him to return back home. We'll be on the Zoom, Your Honor. You are aware how the state feels about domestic violence. And so because there's not been a sufficient cool down period, we would ask for a no further contact and a stay away at this time. The state is also asking for a $2,000 surety bond, no alcohol, drugs, or weapons, nothing further.
Yeah.
Thank you, Your Honor. Mr. Dietrich Brown Clark is 26 years old. He has been in the Atlanta, Georgia area his entire life. He does have family here, including the complaining witness, Ms. Brittany Locken. He completed high school. He states that he has a dental assisting certificate, and he plans to return to school to pursue further certifications in that area. He is currently employed at Amazon. He has been in that position for the past 5 months. He strongly denies the allegations. He desperately needs to get back to work. He was just, hired full-time or as a permanent employee, so he does not want to lose his job. This is his first arrest, and as we heard, my client is adamant that he did not start this. He states that he was basically trying to get Ms. Locken's hands off of him. He wants contact, therefore I am requesting a signature bond. Being this is first arrest, we are requesting no violent contact. We are opposed to the stay away, and I did also have the occasion to speak to Ms. Locken. She states that she wants contact as well. Thank you, Your Honor.
All right, Ms. Locken, I see you there. This is your opportunity to address the court. If you would like to address the court, of course, you're not required to address the court. If you would like to address the court, you will have to unmute yourself, activate your camera, and I'll have to swear you in.
Judge,
So,
I'm asking her to change her attire. It's not suitable for court before I turn the camera back on.
okay.
I'm sorry, good afternoon. I'm unfamiliar with Zoom, so I'm not sure how to start my video.
Okay, there you go, ma'am.
Here we go.
Can you raise your right hand for me?
Yes.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. What would you like to tell the court, ma'am?
Yes, sir. So yesterday's incident was just, I would say, a boil of the trauma from us losing our child fairly recently. I had my child in July of 2020, and he did just pass away. This is a first offense type situation. We have verbally argued, of course, as couples do. And I don't fear Mr. Brown Clark. And as stated, I am comfortable around him and would like him to come back to the resident.
Thank you, ma'am. Sorry for your loss.
Thank you.
Anything further, counsel?
Nothing further, Your Honor.
Nothing from the defense.
As such, it's going to be a $2,000 signature bond for pretrial, 1-day anger awareness, no further violent contact with Ms. Locken, and no drugs, alcohol, or weapons while out on bond. Again, good luck to you, Mr. Brown Clark, and I'm sorry for your loss as well.
Thank you, sir.
Judge, I'm sorry, is it through the jail or through pretrial? I believe you said pretrial.
Yes, it's through pretrial. Okay.
Okay.
How much was that?
It's a $2,000 signature bond.
Okay.
Okay.
I got it. Thank
All
you.
right.
Next, we have position number 7, Mr. Irving.
And that is, we're going in a breakout with this.
So
Let's break out.
we'll be back with you, Mr. Irving. I'm going to discuss this matter with your counsel and a solicitor in the breakout room. Okay, so we'll be back with you as soon as we can. If you will, anybody else need to go into the breakout, Ms. Bacchus?
Anna Helena Allen.
I do, Your Honor. May I please?
Okay. All right, so if we can put in this Helena Allen and Ms. Kim and Ms. Gant, myself, I guess. Let's see, Mr. Irvin, I've had an opportunity to discuss your case with both the solicitor and your counsel, and it's going to be a $2,000 good bond, no further contact with Ms. West, and no drugs, alcohol, or weapons while out on bond. And just let me explain to you what no further contact means. It means no contact whatsoever. Obviously, no personal contact, but no telephone contact, no social media contact, no internet contact. No contact means that you can not contact her whatsoever. If you do contact her, then you will be in violation of this bond, and it may be revoked. See that you have your hand up. You have a right to remain silent. Anything you say can be used against you. Ms. Gann, it appears that he has a question. I don't know if his question is regarding something of a technical nature, or if he has belongings that he needs to retrieve. Or would you like to address that?
Mr. Irving, you received a signature, no, I'm sorry, you received a surety bond. I certainly will reach out to your family as you requested. I'm willing to entertain any questions only if it's related to your bond, but not about the facts of the case. We don't want you to make any statements.
Is it possible I can talk to you?
I can give you a call in the courtroom.
Okay.
All right, thank you.
Yeah, 2392.
Okay, I will give a call. Thank you.
Okay.
Thank you, Your Honor.
Do we have anyone else in courtroom two?
That should be it, unless we're missing someone, Your Honor.
Okay, let me just look through the calendar real quick.
Okay.
Okay, once again, the reset date for the SAP calendar is November the 15th. Position number 1 is reset to the SAP calendar with a $4,000 total good bond. Position 2, reset further notice with a $2,000 SOB through pretrial. Position 3, reset further notice with a $1,500 total SOB through the jail. Position 4 is going to the SAP calendar with a $2,000 good bond. Position 5, SAP calendar with a $2,000 total good bond. Position 6, reset further notice with a $3,000 SOB through the jail. Position 7, reset to the SAP calendar with a $2,000 good bond. Position 8, reset further notice with a $4,000 total SOB through pretrial. Position 9 is going to the SAP calendar with a $5,000 total good bond. Position 10 is reset to the SAP calendar with a $1,000 good bond. Position 11, SAP calendar with a total $2,000 good bond. Position 12, SAP calendar with a $1,500 total good bond. Position 13, reset further notice with a $2,500 SOB through the jail. Position 14, reset further notice, $2,000 SOB through pretrial. Position 15, reset further notice, $2,000 SOB through the jail. Position 16, reset further notice, $2,000 SOB through the jail. Position 17, reset further notice, $2,000 SOB through pretrial. Position 18, reset further notice, $5,000 SOB through pretrial. Position 19, reset further notice, $2,000 SOB pretrial per judge. And position 20 is reset to the SAP calendar with a $5,000 total good bond. Are there any questions, comments, or otherwise?
Yeah, I got some questions. I got some files over here. What happened with Alan?
That was felony transfer. Was that originally position 1?
I don't know. They was on my pull sheet.
Yeah, I can help you with that,
Atkinson.
sir.
Okay. Before we go to that, can I get the other conditions on position 5? I know that there's a $2,000 good bond.
Position 5, the conditions that I have is to stay away from the 626 DeKalb Avenue and no further contact with Mariko Perkins.
Okay, thank you so much.
You're welcome. Are there any others?
Yeah, I had 2 people who didn't come up. Mr. Jordan was one of them.
Yeah, so who all got transferred?
So the Deshaun Allen was a transfer to felony court. Rashonda Atkinson was a transfer to felony court. Antoine Jordan
was a transfer. Richard Petatan Quitiero was a transfer to felony court. Riyad Rahim is also a transfer, and then Ruvon Taylor. That's 6 total transfers off of this calendar. We're just waiting for CP numbers.
Okay,
Judge, you on for tomorrow?
yes, I am.
All right. See you then.
Are there any others? No?
No.
Okay.
Thank you.
As soon as Ms. Gant is back with her client, we'll deal with that, and then I guess everyone can go have a happy Halloween.
Oh, my apologies. I am on the phone, but I certainly don't want to hold everyone up, Your Honor.
Does he have something that I need to address, Ms. Gant?
No, Your Honor. These are just general legal questions.
Okay, all right. So I guess we're done for the day. We appreciate it, Norris. Thank you, and everyone. You all be safe this evening.
Okay, Your Honor.
Happy
Thank you.
Halloween.
Happy
Okay.
Halloween.
Happy Halloween.
And we'll see you all tomorrow.
Bye-bye.